Many of us take for granted our ability to make our own decisions. It's called our mental capacity. We understand, retain, weigh up, and communicate the myriad of options we face every single day. Our brains are constantly making decisions. Some are simple and straightforward as stop, go, turn right, turn left. Others are a little more complex than that. But what happens when our ability to make decisions is called into question? I'm off to meet some leading experts to find out. It's estimated there are 2 million people in the UK who don't have mental capacity due to either a brain injury, a learning disability, mental illness or dementia. In 2005, Parliament passed the Mental Capacity Act to protect these vulnerable people. It covers day-to-day things, like what clothes to wear or what food to buy, to more serious decisions like whether to move into a care home or make a will.
The reality is that others may try to exploit the ambiguity surrounding your cognitive function to argue that you don't have the capacity to make the decision that you want to make. And people deserve to be protected against these often opportunistic and self-serving challenges.
Constance McDonnell QC is a barrister who specialises in disputes over wills. She says a robust mental capacity report is one way to remove ambiguity surrounding a person's ability to make their own decisions.
Anybody who prepares a will for somebody whose capacity may be doubtful may feel the need to commission a medical report at the time that the will is being made in order to underscore its validity and to make it less likely that it will be challengeable after that person's death. If you as a litigator, it would make me think twice, if not 3 times, about challenging a will if it were supported by a good expert medical report.
Very exciting.
Dr. James Warner is Medical Director at Halcyon Doctors, leading experts in mental capacity assessments. As a consultant psychiatrist with more than 20 years' experience, Dr. Warner specialises in the diagnosis and treatment of dementia, depression, psychosis and other mental illnesses. He says that under the Mental Capacity Act, the first role of the doctor is to identify if there's a reason to overturn the presumption of capacity.
I can give you an example of a woman who, to every outward appearance, appears entirely normal. But when you dig deeper into her mental state, she has some psychotic beliefs, she has some delusions that her son isn't really her son, he's been taken over by the devil, and that's why she's rewriting her will. People who are superficial in their assessment of the patient would miss that sort of very important issue that would mean that she would not have capacity.
When someone is close to the point of capacity, a doctor may identify grounds for incapacity where others wouldn't. But their expertise also works the other way round. A doctor may be able to help someone regain capacity where others couldn't.
If someone is close to the point of having capacity, I would always look to see whether we can do things to maximise capacity. This is in fact enshrined in the Mental Capacity Act Code of Practice. So the sorts of things I'd be doing there is perhaps using interpreters, or using visual aids, or seeing someone at a particular time of day when I know they're at their best. And Halcyon Doctors would always try and do these things. The second thing is that quite a lot of mental illness is treatable. And so if someone has depression and then they don't have capacity, and if the decision can wait, then I would say, let's treat this, get you feeling better, and then we'll reassess capacity. And again, the law impels us to do that if we can.
Someone can lack capacity to make some decisions, for example on complex financial issues, but still have the capacity to decide where they'd like to live. If someone lacks the capacity to make a decision and the decision needs to be made on their behalf, the MCA stipulates the decision must be made in their best interests, either by someone who's been granted lasting powers of attorney or by a court-appointed deputy. Tim Snaith is a partner in Winkworth Sherwood's private client team, regularly advising clients on disputes over wills, trusts and inheritance claims. He emphasises there mustn't be any ambiguity about someone's capacity when executing a legal decision.
Where mental capacity assessments become important for us is where client is asking us to do something unusual, is taking a step that would possibly create contention within the family. So I suppose best example might be in a will. If they were to come in and ask us to write one of their children out of their will, which would go against their pattern of giving and pattern of wills over the last 20 years, that's where seeking an independent capacity assessment from a medical professional becomes really important to us. It's really to try to make our client's position as cast iron as possible.
Jake Harwadine of Russell Cook Solicitors specialises in criminal litigation. In her line of work, it is crucial that those accused of crimes understand the charges they face and are fit to stand trial. She says an unequivocal conclusion about someone's capacity to stand trial can only be drawn by an experienced doctor with steadfast integrity.
Expert psychiatrists who look for the tells, the signs that may mean it's something more subtle, and may mean that, in my instance, defendants who face criminal proceedings, very serious proceedings, can't have a fair trial, and that's a very important aspect for vulnerable individuals. So robust reports and thorough reports are critical in my area of work.
As solicitors, we're not medically trained, so there can be circumstances where we're still left with questions personally, and the level of our expertise just doesn't come close to that of a highly trained consultant psychiatrist.
Halcyon Doctors deploys only the best experts with decades of clinical experience, with an intricate understanding of the relevant legal tests, and of course with unquestionable integrity. We believe that is the only way to do it. A mental capacity report that fails to protect you against an opportunistic legal challenge is a report that fails to uphold your most fundamental right, your right to make your own decisions.